Let's see if they don't pass right now.
So good afternoon, everyone. How are you today? I can't hear you.
We're very well, Ma.
All
Good
right, thank
afternoon.
you. Sorry, I took this long. Um, okay, so Hadiola, please. So when is our class? When are we going to conclude the class? I sent a message to you earlier regarding the timing. Is he here?
Yes, ma. I'm here, ma.
So, what's the decision regarding the time?
Yes, ma. We are still looking at our timetable, ma. We've
Yes,
not decided, ma.
for almost an hour.
Yes, ma.
Okay,
Uh,
so
I was in the lecture then, ma. That's why.
okay. So we're thinking 4:30, that will conclude the class by 4:30. So okay, I also have dropped, so I'm also expecting to have more than 500 students here. Okay. So that's the reason why a few of the times we don't encourage online classes. And if we are going to encourage it, then everyone should be here, because it's just with your phone you can connect. So I'm just saying 221 students here. But then I've also dropped a YouTube link with Adeola, because I was expecting to get more than 500 students. Whatever the case may be, let's just continue with our class. So, Adeola, were you able to send the recordings to your class, to everyone?
Yes, ma. The YouTube link you sent, ma.
Yes, I sent a YouTube link to you. Have you sent it to
I sent it,
everyone?
ma.
All right.
Yes,
So,
ma.
all right. What are your questions regarding the link we sent to you, regarding the topic I sent? In that YouTube class, I've concluded on capacity to contract. And the reason why I try to do that is so that we don't take too much time on that. We can quickly move to the next topic. Please, what are your questions? Okay, so there is Percy Nwose. Don't worry. Okay, so Pets and Guards has a class between 4 and 6. All right then. Thank you. So I want to assume. So Oyekomi, you can get the class. You can go to my YouTube channel. I have also dropped the link with Adeola. Just go there, all right? Because for Zoom they do a lot on my email and they drop a lot of messages, and I don't want that. It's just make my email, it fills this up and I don't have enough space for my important messages, okay? So just go to my YouTube link and, channel. You'll be able to see this lecture. This lecture that we're having currently, all right? I've actually dropped a link with Adeola. I'm asking again, or would I say for the last class now? For the last time, can we move on to privity of contracts? Because you now get to understand the details in capacity to contract. Okay.
Yeah.
Okay, so let's go to privity of contracts. I'm going to share my screen now. Oh, this another thing that I noticed over the years, that a lot of times students used to say we should not use our video so that it doesn't run down. I don't know, is it their network or their data? I'm not getting response. It's okay. So today we are going to go ahead with privity of contract. With privity of contract. And the whole gist behind privity of contract is that when Mr. A and Mr. B agree to contract, the reasoning behind privity of contract states that no other person can benefit from that contract except Mr. A and Mr. B. That's the rule in privity of contract. And I'm very sure everyone here too will want to agree in that manner, in that line too. Okay? That when A and B enters into an agreement in which they confer benefits or obligation upon C. Okay, so give me a minute or two, please. Okay, so in which sorry about that. In a situation where A and B enter into an agreement in which they confer benefits or obligation upon C, who is a stranger to that agreement? The question that arises to start with is that, can C receive benefit or incur an obligation through that contract? The general rule, like I have stated, is that under privity of contract, a person who is not a party to a contract cannot sue or be sued on it. So, in the example I've given now, Mr. C, who is expected to benefit from that contract, cannot sue based on that contract. He cannot sue for the benefit that accrues to him, or neither can he be sued for the obligation he's expected to do. All right. So let me just give another example. Where you have 3 of you in a class, okay? The 3 of you, you are Tade, or let's say A, B, C. A bought a phone for Mr. C from Mr. B. Now, the thing there is that when Mr. C was given, let's now assume Mr. C was supposed to go and pick up the phone from Mr. B. But on getting to Mr. B's office, Mr. B did not release the phone to Mr. C. Under privity of contract, Mr. C cannot sue Mr. B. It is only Mr. A who has paid for the phone that can sue for it. And if there's any obligation that is required from Mr. C, Mr. B now or Mr. A cannot sue Mr. C to perform the obligation. That is the rule under privity of contract. All right. And the reason for this is so that we don't have multiple of actions. The reason is so that we don't have people that they are just ordinary, or would I say people that were gifted things, so that they will not come and start claiming for rights that is not due to them. But then, what do you think are the exceptions that can arise from this sort of contract? So I'm trying to ask a question and I read the response. What do you think can be an exception to when there is a beneficiary and that the beneficiary cannot sue. Can you think of any exception?
The death of
Yes, ma'am.
the beneficiary and the next of kin.
At the death of the beneficiary, okay, that their next of kin should do what?
For example, if the person dies and has like maybe a contract with someone to pay and the next of kin, then I believe then the next of kin can probably sue to probably get the maybe the contract fulfilled, or for example, maybe you have money in the bank, so the next of kin can go and get the money, though the contract is between the person and the bank, not the next of kin and the bank.
Yes, that's a very good one, and we can see that under trustees. But then we are going to refine it better. But then really, you have really tried. I like that contribution. So we have a lot of them. Who can try to give me another? Who can give us another?
Ma, like, hello, ma.
Yeah, I can hear you. Thank you.
Yes, ma. I think we can look at a situation where one rents a house through an agent and something goes wrong. I think automatically the person who wants to stay can actually sue the landlord because the landlord actually permitted the agent to work on his behalf.
Remember, that is an agency case. And whatever an agent does is as if it was the principal that did it. So that is under the kind of contract you just mentioned. If that analogy says A is the agent is also the principal, and they are both A. So really, that is not really a strict example, okay? Because the agent is also seen as a principal under the law. Do you understand?
Yes, ma.
Okay, so thank you for trying. That's very good. So I'm expecting more contributions. Okay, so let's just move. Okay, do we have another person?
Yeah, I'm thinking in the
Okay.
case of getting a land or something like that.
I can't hear you clearly. Thank you. Just increase the volume.
Okay, I said in a case of getting a land, like land matters, land issues.
We are here. You know, is this land issues? Then what happened in land issues? You are not. Is it your network?
I was muted. All right. So, for example, in a case whereby uh you are renting a space, from someone, and that person is not the actual owner of the land. I think, okay, let's say ABC. Mr. A is the owner of the land,
Okay.
and he rents it to Mr. B, and
Okay.
Mr. B is also like giving it out to another person to use for like a period of time. Yes, so
Like
I
a
think that
sublease.
is good. Yes, for a period of
Okay.
time. So it's going to affect. So everybody is tied to the contractor. So yeah, that's what I
Okay.
think.
So thank you very much also for your contribution. And I would also say that may not also work here. So it would only work if under that sublease, there is an agreement for sublease. It's not in all cases that sublease is acceptable. There are times, or even in most cases, it is not acceptable. All right. But then in cases of sublease, if you sublet something from another person, it is at the death of that person who was the original tenant that you can come in and start claiming. And even at that, you have to be recognized by the landlord. But let me just give you, so I don't take too much of your time, but I like the fact that you're all thinking aloud and you are giving me, I'm getting what you're thinking from you.
Ma, can I try?
Okay, please.
About a scenario whereby since party A and party B are in a contract with each other, but in a scenario whereby one of the parties is not available to act on the contract, but there's like a written consent to party C to act on his behalf. can he also sue in that case?
So thank you very much. Your example is as similar as the example of the landlord and the agent. When you give somebody an authority, it's as if you are the one acting. So it's not a separate Mr. C. Do you understand?
Oh,
It's
okay,
as if
ma'am.
you are still the one working. But then, thank you for your contributions. I think at this time, we can then move, all right? So these are the exceptions. These are the exceptions. Yes, it's the same as power of attorney. And yeah, this is the case of agency here. Now, a principal may, under certain circumstances, sue or be sued on a contract made on his behalf by his agents with a third party. All right. We also have, and looking at this now, the last speaker and the speaker who had spoken on the issue of agents will actually get it right, would actually get it right. In most cases, an agent is seen as also working for the principal. Is also the principal, is not a separate personality. Whatever the agent has done is as if it was the principal that had done it. All right. In as much as it's seen as is actually seen as an exception. All right. So another exception which really aligns very well is this trust exception, which one of your colleagues had mentioned. You know, where two parties enters into a contract for the benefit of another. And this, let me just give you an example, a very good example of this. Where a father drafted a will, and under that will, he has some executors, or would I say administrators. The executor, which can also be referred to administrators, the father had a contract with them that when my children attain the age of this and that, they should be given this house at Abuja, another one at UK, another one in the United States. If after the death of the father, the administrator did not release the content of the contract to the children who are beneficiaries can sue the administrators to ensure that the administrator does as the content of the will as stated. That's for the case of trustee. Okay. Another one is in the place of assignments. An assignment can happen in places of transfer, where a person is an entitled, the title on a certain thing is transferred to another person. Now, the child of that person, and I think one or two of you are giving an example like that too, and I was trying to pull it together, that for example, Mr. A buys a landed property from Mr. B, right? For the benefits of their children, even it could be for their own benefits, and after their death. Privity of contract cannot stop the children of Mr. A from suing cannot stop the children of Mr. A from suing Mr. B if Mr. B tries not to hand over the papers of the property to them. We are in number C now, which is assignment. Are we on the same page? Do you need me to go back?
No.
Okay. So that's for assignments. And I gave an example under assignment. I said land. So under the fourth one is covenant relating to land, which had given that example with assignments. So assignment does not really have to be land. It could be other things, right? It could be that you assign somebody to, you gave them something else. It may not be land, all right? The fifth one is statutory exceptions. That means exception under statutes, and we have under insurance. Can you remember third-party insurance? I need a response to know that we're actually moving together.
Yes.
If you can remember third-party insurance, a third party can sue an insurance company for a claim. It doesn't really have to be the person who had insured the third party. The third party who maybe, for example, motor accident insurance policy. The third party whose vehicle was damaged. You know, a lot of the times you can get the record of people's insurance. You don't really have to go to the person. You can always go to authorities that deals with motor insurance, authorities that deals with vehicles. You know, you can always go to them and get information, because those information becomes public documents. Immediately you pay for license and all of that. License over vehicles or vehicle papers. Immediately you do all of that, those becomes public documents. So you can actually sue through, you can always get those information from those government authorities. You get the information, you can ask, always make an application to the insurance company. But after such application, if the insurance company would not do as expected of them, then you can go ahead and sue. So a third party, especially in the case of third party insurance, can always sue the other party. I mean, the insurance company, if they will not do as expected of them. So also in banks, commercial credits, you know, so this kind of, this is developed to expedite international trade by facilitating prompt payments. So a buyer who opens an account at a bank for benefit of the third person who is a seller. Now, in case the bank will not do as expected of them, the third party on whose benefits the account was opened for can sue the bank without going through the buyer. Now, these are exceptions to privity of contract. And if you look at all of these exceptions, a lot of the times, one way or the other, you all are aware and you are being a party to this. So let's now assume you are involved in a contract with somebody. You should always put all of this into consideration. Always think of how all of these things can avail you, how these things can protect you as against the law in privity of contract. So do we have a question here? Any question, please?
Yes, ma'am. I have a question.
All right, please go ahead.
What about the case whereby Mr. A issued a check to Mr. B?
Issues?
Then a check to
Okay,
Mr.
okay.
B. Yes, ma'am. Then Mr. B now actually wants to exchange, maybe purchase a goods from Mr. C. So can he use that check as a form of payment to Mr. C? So that
So
Mr. C
remember,
can.
okay. Remember, a lot of the times when they write a check for people, they write the name of the beneficiary there. So you cannot use a check, because by the time if you want to pick up the money, if you want to cash the money, they will ask for your ID card, which contains your name. So a lot of the times is not for the third party. So a third party whose name is not on that check cannot pick that check up. Do you understand? So the exception in privity of contract cannot avail Mr. C. Except if it's, I think there are some checks that they call open checks. Except you are given an open check that you should go and fill whatever name you want to fill on it, except that. But the check in which your name has been written on it, the bank will not give somebody else's, will not give the money to another person. I am sure Nigerian bank will not do that. So, do we have another, I should have even asked a classmate to respond to it. It will have been fun. So let's go. Another question, please. So somebody is asking to transcribe this thing. I don't know why a lot of you do this. So, okay, it and go. All right. Do we have another question?
Okay, ma, there's
Yeah,
a question.
okay.
Yes, ma, you were talking about the agency stuff the other time, and you said the agencies can be assumed as the principal, but I'm also seeing agency here as an
Yeah,
exception.
that's
So,
what I tried to address when I started. Now,
okay,
I said, yes, I'm trying to say the agent can actually be seen as a third party, but in most cases, it flies, all right? But in most cases, it's just like a, how will I now put it? You know, that agent was actually there just to fix the point that Mr. C, who is an agent, and of course, remember, the agent is working as if he's the principal. Whatever the agent does is with the consent of the principal, all right? So whatever the agent does, the principal can always sue. The user who is a Mr. C can always sue. It's actually, it's the rule. I'm just trying to ensure for you to know that the principal is also the agent in most contracts. All right? Okay. Do we have another thing? Can we move now?
So, Mark, I'm trying to record it.
I can't hear you, please. Okay.
My said, can the class be recorded?
I said, you know what I said now? You can always go and pick it up on my YouTube. It's the same thing now. Do you understand? And this one actually has,
Okay, yes.
yeah, it's the same thing. I just like to have it there. For instance, for next year, I can always give it to the next set to go and I can send it to them to listen to before my class. I've not actually been doing that, so I just think to start that so that the other class can also benefit. Do you understand? Okay, so
Yes, ma'am. Thank you.
that is it for contract, the elementary part of contract. That is it for the elementary part of contract. Now, the question that I want to ask now, I wish I had not put it here. Aside from capacity, apart from the fact that some people do not have capacity, and the law tries to protect them, there are also some other things that can nullify a contract. There are some other things that can vitiate a contract, means the other things that can make a contract invalid. And these other things are mistakes, misrepresentation, duress and undue influence, and illegal contracts. So the reason why we are doing all this is for you to know that aside from the fact that if these 4 elements that we have earlier mentioned, offer, acceptance, consideration, and intention to create legal relations, if they are all in a contract, and in fact, if the party if the party has capacity to enter into that contract, there could also be some other things that can vitiate a contract. There could be some other things that can vitiate a contract. So we are going to take mistake. So the definition of mistake. All right, let's see. I'm sure you have read what I just slide on. Who want to tell me what mistake is? Who want to try the definition? You have read it already. So I just try to remove it so that you can do it by yourself now. Who want to give me the meaning of mistake? Do we have a trial? Who want to try the definition of mistake? Can you hear me?
Yes, ma'am, we
Yes,
can
we
hear
can
you.
hear you, ma'am.
Okay then. Okay then. So who want to try the definition of mistake?
Okay, Ma, can I try?
Okay, please go ahead.
From my own definition, I
Okay.
think that a mistake is probably in a contract, there's like a misrepresentation of the facts, probably on purpose or with an intention to mislead. I think that's what a mistake could be called.
Okay, thank you very much. I like another definition. Any other person who wants to try mistake? You are right, because there are times some people misrepresent, and we are going to see it in another type of mistake on. That's actually right. And I just want a straightforward. If you're able to give me a straightforward definition. Who want to try this time again? What I just acknowledge and what I appreciate with your class is that you are willing to contribute, and it's a good thing anyways. It's a good thing. So I need somebody else to speak to it so that we can quickly move. Let's see how far we can go today. Anybody? Okay.
Can I try, ma?
All right, please go ahead.
All right, ma. I think we can see it as a vitiating element of a contract in form of misconception about a material fact about that particular contract.
So thank you very much. I love the misconception that you used. If possible, we can clap for her. Everyone has tried. I just love the word she used, okay? Misconception. So you know
It's
what?
a him.
What we have noticed, or what the mistake that the things that happen at times is that a lot of people, when defining terms under the law, they define it as it were in an ordinary parlance. Ordinarily, if you want to define mistake, ordinarily, which is outside of law, you could say, oh, when somebody does something that was on purpose, that was not purpose, they didn't do it purposely. Right? And like the other speaker, the first speaker had said, you notice that he was deviating a little bit from the fact that mistake doesn't really have to be that the person didn't do it purposely. Under the law, mistake can still be termed as something that people did purposely. But in our ordinary use of language, we always see mistake as something that was done unconsciously, that it was not purpose. It was not a purposeful thing. It was not as if they did it purposely. So my speakers, those that have answered this question, have answered rightly. And I want to believe that they did it all by themselves and not because of what they had read. So I'm going to give you an example of what a mistake is. And the example I gave here is a contract. For an example, A enters into a contract with Mr. B, and his intention was to buy. Now, Mr. B has two types of vehicle. And I'm going to use Peugeot because I think I know Peugeot. I think there is a Peugeot. Is it 508 and 509 or 507 and 508? Let me use 507 and 508. Now, the 508 supersedes 507. Now, Mr. B has two types of this vehicle. The intention of Mr. A was to buy Peugeot 508. The intention of Mr. B was to sell Peugeot 507. So when Mr. A made the payment and Mr. B tries to give him Peugeot 507, he sees the vehicle. Under the law, they have both made a mistake. Under the law, they have both made a mistake. All right. So it is agreed for such a mistake to be, anyway, when we, just to ensure that I'm not getting too far than expected. Under the law, that is a mistake. It is quite different from where Mr. B has just one vehicle that he wants to sell. If he has a vehicle that he wants to sell, and Mr. A had gone to see the vehicle, and in his mind, he was thinking in his mind that the vehicle is a Peugeot 508, whereas the vehicle is Peugeot 507. If after making payments, Mr. B gives the vehicle to Mr. A, gives Peugeot 507 to Mr. A, under the law, that is not seen as a mistake. Because Mr. B only has a vehicle. And it is the vehicle that Mr. B has that Mr. A asks to buy. So under the law, that is not a mistake. It becomes a mistake when Mr. B has two vehicles and there was a misconception regarding what Mr. A wants to sell and what Mr. B wants to buy, or vice versa. Do you understand my explanation?
Yes, ma'am.
You can also use the
Yes,
chat box. You don't really have to talk. You can also use the chat box. So here I said for the second example I gave, Mr. A wants to get a vehicle and he got a vehicle. It's quite different from in a case where Mr. B has two vehicles to sell. Okay? So mistake in the legal sense.
No, my muted.
Okay, so I'm back. Sorry, sorry about that. So mistake in the legal sense is more, like I said, is more limited in meaning than the general usage. So like the example I've given, where A intends to buy from B, who has two things. And so they both had misunderstanding regarding to what to be sold and what to be bought. It's quite different from where they have just one thing. All right. And that one thing was delivered to the person who asked for it. But then subsequently, he couldn't, he was saying he made a mistake to have made the payment. And so that should not be regarded as mistake in law. So in the law of contracts, we have three types of mistake. We have common mistake, we have mutual, and we have unilateral mistakes. So let's see what we can do before at times we run out of time. So under common mistake, this is like mistake that the both party both made. Now, the example I gave to you is regarded as a mutual mistake and not common mistake. Now, common mistake is mistake that the both party made mistake regarding the same thing. They made the same common mistake. All right? But when it comes to mutual mistake, they made mistake. They actually made mistake, but on different things. And that's where that my example can come in. All right? So I'll give you an example for common mistake. So let's assume that Mr. A wants to sell his property, and his property is at Ibadan. Mr. B showed interest that he wanted to buy. Mr. B had been to Ibadan. He had checked on the property and he liked the property. Now, Mr. A and Mr. B both lived in Lagos. So on a fateful morning, they had agreed to meet at KFC to sign papers. They both got to KFC and they signed papers. But at that moment, maybe 30 minutes before they signed the papers, that house was already burning down. It has gotten burnt down. But they went ahead. They didn't know anyway about the house being burnt down. Neither of the party was aware of what happened to the house. So like within that 30 minutes, they had signed the papers and parties. It was not until 20, 40 minutes that the buyer got the information that the house had been burnt down. Now, in this kind of example, they both had made a mistake regarding that one house. They were not aware. They made mistake not knowing that the house that they are the same house they are contracting for had been burnt down, had been destroyed. In that case, you say you have a common mistake. We call it same mistake. Is that understood? Do you understand that? So then we have
Yes,
mutual
ma'am.
mistake.
Yeah, ma'am.
What is mutual mistake? Mutual mistake is what I have explained to you earlier, where Mr. A wants to buy from Mr. B a vehicle. Mr. B has two types of vehicles, right? And he intends to sell one type, and the Mr. A who wants to buy intends to buy the other type. Now, they both made a mistake, but then on different things, on two different vehicles. So, in other words, party misunderstood each other, although they made mistake. All right? In most cases, all these mistakes are made, I mean, for the first and second types of mistake, common and mutual mistake, they are made in good faith. They are mistakes that are made in good faith. Now, going down to unilateral mistake. In most cases, unilateral mistake occurs when one party, for example, fraudulently misrepresents facts to the other party. And that would go with the example that one of your colleagues gave. All right? where one party tries to say, fraudulently, they have an intention to mislead the other person. In that case, the two parties didn't make mistake. It's only one person that make mistake. Now, the person who was giving that misrepresentation of fact is the person who had made mistake in this regard. And that is why we call it unilateral. One person had made the mistake. Excuse me, please. So some of my students are knocking at my door, and so they've been disturbing me. Sorry about that. Okay, so that is for unilateral mistake, where one person is misguided. So I'm going to give you an example. There are times that you want, if a name of a person is mentioned, you would love to contract with such a person.
27-year-old one.
So I thought this class would give me benefits of how they're going to be nice and they are just doing something else. What is this?
Robo, please, can you mute your mic?
Oh, Godfrey, please mute.
Okay, let me try to make Adeola the whole. It's just going to take too much of my time. Okay.
He has muted, man.
All right, thank you very much. So that is for unilateral mistake. And I wanted to give you an example. I said there are some people that when you hear their names, so I'm going to give you an example. Who can give me a top engineering firm in Nigeria? One of the top engineering firm in Nigeria. Or would I say, is it civil engineering? Or yeah, let's do civil engineering.
Julius Berger.
Julius Berger. Or can we use someone, because those ones are okay, let's use Julius Berger. And so somebody, you were at a meeting with somebody, right? And that person has been talking that, oh, I work with a very big establishment, and we've been meaning to do business with Julius Berger for a long time. We've met with Britain and they will not show up, they will do this. And you're like, but I work with Julius Berger. I am their, maybe I am their, you are a top management, you are one of the top management there. And you work with them and no problem. Let them bring in their, what do they want to do and all of that. And because they heard you saying that you work with Julius Berger, they met with you, and I'm using this, it may not totally align, because if anybody will want to sign papers with Julius Berger, the name will be broadly written on it there, that you are working with Julius Berger, that the file, whatever agreement you are going to sign but then you gave them your proposal and they went ahead and they paid into an account. We are just using Julius Berger. We could use some other names that are well known, all right? But then they paid into an account. And after paying into the account, they discovered that they have paid into a wrong hand. Under that kind of a case will be seen as a unilateral mistake. It will be seen as a unilateral mistake because the mistake, one person tried to disguise themselves as another person. And so on that note, you who had given that person, or that person who has given you the contract is the only one who had made a mistake. And so regarding that, you can see that as a unilateral mistake. So that is for that. So let's try to look at mistake under common law. Do you understand these types of mistakes? And I hope it will not, if you are given a question regarding any of these three, you can answer them. You can send me a chat. You can just give me a yes or no so that I will know what to do in your chat box. So to me, it's as if none of you is in class. So this is the reason why I don't do online class.
Yes, we can, ma.
Now, even with this online class we are taking, I can only see 257 students. And Adeola said that room will not take you all. I'm going on. What then is mistake at common law? Let's look at mistake at common law. I hope you can remember that in class the last time I tried to explain what common law is and what mistake in equity is. What common law is and what equity is. All right. So like I was saying the last time in class, that common law most of the times has a very strict, is very strict. Common law is strict, but equity tries to take away the strictness of common law. So under common law, it takes the view that where a mistake is such that it prevents the formation of a contract, then the contract is void. So this kind of mistake is known as operative mistake. That means operative in the sense that if that contract cannot go ahead, that mistake has rendered the contract void totally. That means the parties cannot do anything. That mistake has rendered it void. Okay, look at the contract about the example I gave to you about somebody disguising as if they were Julius Berger. Do you think after discovering that the person who has disguised himself as Julius Berger, if the other person gets to get the identity of him not being Julius Berger, can they still go ahead with the contract?
No, ma.
So it's operative. It's an operative mistake. And see, we can see it. We have some mistake that can be a subject matter. Some can be the terms of the contract. The last one is the party. The example I gave to you is regarding party to a contract. Now, if there is a mistake regarding the party to a contract, it can render the contract operative. It can render the mistake operative and the contract void. All right, and when it comes to subject matter is the main purpose of the contract. If you are saying you want to buy something, and that, let's say for example, that's mutual mistake of wanting to buy 507, wanting to sell 507 and the other person want to buy 508. Do you notice that the subject matter is in contention? There's a mistake as to the subject matter. In that regard, that contract will be seen as void. That mistake has rendered it void. Except in a situation where the person says, oh, don't worry, you can give me the 507. All right? But in a case where such is not the case, then the subject matter has rendered it void. Let's look at equity. The essence of equity is such as to reduce the strictness of common law. And so, for example, in the case of operative mistake, equity follows common law and the contract becomes void. However, where a person enters into a contract under a mistake, which is non-operative, that is contract that is good at common law, the mistaking party may obtain equitable relief from its contractual obligation. That is, for example, where the mistake is not operative, is not such that will really, really goes to the root of the contract. So who can give me an example of an inoperative, non-operative mistake? An example of non-operative mistake.
Ma, can you hear me?
I can hear you, please. I can hear you. You can go ahead. Is it the network? Can you all hear me? I have a lot to go with.
Yes, ma'am.
Yeah.
Still a 508, it's just the color difference.
You said what?
Can you hear me, ma?
You. Yes, I can hear you.
Oh, so I said using the subject of the sale of the figures 508 or 507. For example, the buyer wants a yellow figure 508, but the seller mistook it for as a blue. Like the person wanted a blue, the misconception was about the color. I don't think that goes to like the root of the contract that could void
So
it
thank you
entirely because
very,
it's
very
still a
much.
508.
In fact, you nailed it. If you can please clap for her, please do. If there's a place where you can clap for her, please. She really nailed it. Those are kind of inoperative mistake. Now, I want you to please excuse me for 5 minutes. Please excuse me for 5 minutes. While you are doing that, I want you to be going through this, the first part here, documents mistakenly signed. All right, thank you.
Yaji's iPhone mute.
Okay, thank you, I'm back. So as not to waste too much of my time. Okay, so Adiola, can we take attendance now? Attendance within the next 3-4 minutes, please. If after that time, and I don't want to have more than 244 people here. If I get more than 244, then the attendance will not be accepted. So let me see.
Sorry, ma, how are we going to drop the attendance, ma?
I want you to go to the chat box and quickly put in your matric number. In the next 4 minutes. Now I'm getting 257. You know, I told you at this point, by 3:15, I won't, these people that are coming in, you know, I have your records. So these people that are just coming in, your attendance is nullified, though. All right. They should still call, they should keep coming in. And that's very unfair on yourself, not to be in class that has went due. When we are taking attendance now, they are coming in. That's good. All right, let's go to documents that are mistakenly signed. Documents that are mistakenly signed. So the general rule when it comes to documents that are mistakenly signed is that a person that puts his signature to any document whatsoever, whether mistakenly signed or not, is bound by the terms of the contract or by the terms of that document, whether he read it or he did not read it. So like I used to say to people, whenever you get any documents, the first thing you should do is, if you are not able to read it at that time, it's better you take some time off. Tell the person, I need a day or two to go through these documents. If not, if you go through those documents, if you sign the document without having read, understood the documents, then you are putting yourself in jeopardy. It's going to be very ugly if anything comes up from it, because you cannot deny the fact that I signed the document. So that's the first thing that I normally say to people. So if a person signs a document, is generally bound, liable by whatever. Yes, yes, Joshua, can we hear you? Joshua is saying something. We have less than 7 minutes, so I can conclude on time. Joshua, all right, let's go ahead. So the law developed a defense anyway at some point, because at some point it was now discovered that a lot of people could not meet up. And at times it was due to some cogent reasons. So the law developed a defense which is open to a person who has signed a document mistakenly. And we call it that we have a legal maxim for it. It's called non-ex fatum. That is, it is not my deed. What I have done here is not my deed. It's not my doing. So if a person had a deed read over to him and they did not read the document to them correctly, and that person affixed their signature, such a person will be excused from liability. I think you have read it and you understood it. It's very simple. Although the defense is actually restricted at some point, because if you allow everybody come and say, oh, when they read it to me, I didn't understand. Some people can even use it. They can do it purposely. So the law has restricted it to that there are a form of restriction to it. So there's a restriction to the certain set of people that can plea. For example, an illiterate person can plea under this. A person that cannot see properly, that cannot see properly. It's not only those people that can see totally. There are some people that they cannot see properly. They can come under this plea. Also, another restriction is negligence. All right. So you cannot say if it's under negligence, if you do it negligently without care, the plea will not avail you. Also, for example, where this comes up as a form of under unilateral mistake, it will not avail them, because especially if it's a fraudulent person who is seeking for this plea, the plea will not avail them. If there's any question, I'm here to take any question. And in the absence of none, Adeola, when have you agreed that we meet this week regarding because of the day we couldn't meet? If Adeola is not here, can we hear from another class rep? So that means Adeola did not attend the class. That's good. So, another class rep, any other class rep? So, he's in another class. What do you mean? Is this class not between 2 and 4? Do you have another class when this class should be taking place?
I'm here.
Someone said you are in another class. ATM.
It's the network, man.
So when are we meeting again, please?
Yes, ma. We had class, ma.
Yeah, but you forgot when you guys went for. I was there. I couldn't take the class, and I was not informed. So I need that class. It could be an hour. It doesn't really have to be too much. So every one of you can hear now. When I need a day notice. The one you sent to me that time was just within hours. I was doing something else that day. I can't just do it that way. Please agree with your class members, with your colleagues. Let's fix just an hour is okay for me.
Okay, ma.
Okay. So how is Friday 2 to 3 p.m.? Everyone, you are all here, Friday 2 to 3 p.m.
No, ma.
No, that's fine.
No,
Do
ma,
you have a
please, ma.
class? Do you have a
No, ma,
class?
please, ma.
Do you
So
have a
much,
class
ma.
at that time?
In electrical one, it's likely some of us are taking an elective that will be
Jumat
building
end by
around
3,
that.
ma.
Around
Okay.
We
So
have
yes,
how
lab
and
about 3 to
Jumat.
4?
3 to 4 can work, ma.
How is 3 to 4? Everybody, please. I want us to agree on it now.
Ma, is it going to be on?
It has been this one we did online. How many of you attended? I'm just doing my own for God. And if you want the morning of Friday, 8 to 9, let's quickly agree to one time now. Morning on Friday, 8 to 9 or 4 to 5.
We have BUS from 8 to 10.
Electrical has a class on Friday morning 8 to 10, another class from 10 to 12.
How about
BUS.
for 3 to 4?
Ma, can we get back to you about the timer?
No, the
We should
issue
meet
is
and
that
then
electrical, check your timetable. You all have your timetable with you now. Check it. Let's agree to it. The last time it got to me too late, and I don't want that to happen again.
Ma,
So that from now,
mechanical,
I will
3 to
start
4 is
preparing my
fine.
mind for the class. You all have your timetable. How is 3 to 4 on Friday?
Mechanical, 3 to 4 is fine.
Well, it's fine. Sorry, ma, would the class be physical or online?
It's online. There's no room. We can't physical class with a large class for a reschedule thing like this may not really work. So let's do
3 to
online.
4 is fine, ma.
3 to
Ma,
4.
3 to 4 is fine, but medical,
Now,
ma.
all the
3 to 4 is
classes
fine
are
for class.
represented here now. This is the time to tell me it's not convenient. So I need to confirm now, 3 to 4 on Friday. If you have a class, let us know now. We'll check through your timetable. Systems, what do you have between 3 and 4?
It works for
We have image processing by that time.
What course is that?
Image processing is the systems course.
3 to what?
3 to 5.
How about your morning? That is 3 to 5, right? How about 5 to 6? I'm here till 7. I just want to ensure that I finish this, my face, and I move.
Yes, ma. In surveying, we have lecture 4 to 6, ma.
Which of the courses?
On Friday.
What course is that?
Yes, ma.
I'm going to meet with your
Hydro course, ma.
timetable officer. Let's see
Hydrographic
what
surveying.
can do. Yeah, I'll collect your timetable from the timetable officer. Because if Adiola, what of the time you are proposing to me on last week, Friday? Is it not the same Friday I'm proposing now? So how would we have done that the
Yes,
last
ma.
time?
Yes,
How
ma.
would we have done it?
This lecture is like an arranged lecture. It's an arranged lecture this week, ma. It's an arranged lecture this week,
When I
ma.
was supposed
4
to
to
have a
6.
lecture with you, you guys said you were playing football. And you know, every week counts. It's not as if the school will now say, because you have your football, then they will extend the time for us. The time is not extended.
So Emma, I think we should work with 3 to 4 on Friday for now. Then maybe systems class rep will reach out to their lecturer and ask if they can shift their class.
You know what I'm
Systems,
thinking
a
of?
student in systems just said the class will no longer hold 3 to 4.
Yes, I understand. I understand that. This is what I'm thinking of. And if you all are going to be cooperative with me, 6 to 7, 5 to 7. Someone said there's also 6 to 7. But you know what? Like someone had said, someone is saying 5:32. No. Okay, someone said 3 to 4 systems no longer holds at that times. Precious Michael said that 3 to 4 classes for systems no longer holds. So what is the meaning of the lady that said 3 to 5? Are you sure you are in systems?
No, she's not taking the course. We eventually moved it. So she's just following the timetable, but we've moved it already.
Okay, so are we sticking to our 3 to 4 now?
Yes, ma'am.
Okay, thank you. 3 to 4, I'm going to send a Zoom link to you now. So we are getting prepared for the class. Enjoy your weekend. Bye. Oh, we just started the week today.
Thank you, ma'am.
Thank you, ma, for the class.
Thank you, ma. Thank you, ma. Thank you, ma.
Ma, what about the slide?